light bulb moment from your first big idea. It's the decision to set out on a new path. It's the realization that entrepreneurship starts with a spark, and that spark starts here. At the Stu Clark Center, we're here to nurture your ideas and help spark your entrepreneurial spirit. How? How about competitive opportunities to free your inner entrepreneur? Advice from venture coaches who have walked the walk. Or some of the best networking events you'll find on campus. You'll find it all right here. By focusing on education, awareness, community, coaching, and connection, we build strong relationships with our students and do everything we can to help them on their journey to self-starting. At the Stu Clark Center, we thrive when you thrive. No idea is too big or too small. The Stu Clark Center is your one-stop shop for everything you need to start your journey. So why not start today?
Good morning and welcome everyone to our webinar today as part of the Stu Clark Center Winter Webinar Series. Super excited to have you all join us. We have an awesome webinar lined up with three amazing student guest speakers from the Carey Vicker Business Law Clinic and the Robson Faculty of Law. Today it's all about legal fundamentals for startups, so we're super excited and thank you so much for being here. We're really looking forward to this webinar. Before we begin, just a couple of housekeeping items and Zoom etiquette reminders. Your video is optional today. However, we do ask that you please stay on mute throughout the webinar just to keep any distractions and background noise out. If you have any questions throughout the webinar, please feel free to pop them in the chat. We will have a Q&A session with our guest speakers today following their presentation. So if you have any questions at any point during their presentation, throw them in the chat and we'll get to them during the Q&A session. And finally, this webinar will be recorded and it will be uploaded to our online resources section of our website, just as all of our past webinars are as well. In case you have to leave early, totally okay. You can catch up and watch it later. Or if you think that someone else would find value in what you've seen today, you can feel free to share the link with them later as well. And on that note, feel free to check out our library of past recorded webinars as well. I would like to introduce our Stu Clark Center for Entrepreneurship team, Deborah Jonason-Young, our director, Lindsay Friesen, our program coordinator, and myself. My name is Joshua Zapperzan, and I'm the venture coach at the Stu Clark Center. The Stu Clark Center, we are here to help and support you on your entrepreneurial journey however we can. So please do not ever hesitate to reach out to any one of us there on the screen. Like I said, we're here to help and support. If you have any questions about the center, about what we do, or about how we can be of assistance to you in your entrepreneurial journey, please don't hesitate to reach out. You can find us online at umanitoba.ca/entrepreneur and also on Instagram at Stu Clark Center. So toss us a follow and stay up to date on all the latest news, events, promotions, and contests. As I mentioned, I'm the venture coach at the Stu Clark Center. I want to briefly just tell you a little bit more about what that is. The venture coach program, it's an absolutely free resource for students. It doesn't matter what faculty you are in, what year in the program you're in, or what type of business idea you have. It is an absolute free resources for students to help lead you into startup land. Whether maybe you have an idea for a business, but you don't know how to start, or maybe you don't even have an idea, but you're wondering more about what entrepreneurship is, how to maybe come up with an idea. Or maybe at the far other end of the spectrum, maybe you already have a business that's operating, that's producing revenue, and you're wondering, what do I do next? How do I grow? How do I scale? There's no idea or no question that's too big or too small to start at the Stu Clark Center. So I highly encourage you to visit us online, umanitoba.ca/entrepreneur, and you can learn more about the Venture Coach program and book in your free meeting with me. You can book as many as you want and at a time that's most convenient for you. We use the Startup Tree platform, which you're all familiar with because you used to RSVP for this webinar. So you can also access everything through there. I do want to quickly draw your attention to not this coming Saturday, but the next Saturday, April 17th. It is our annual Stu Clark New Venture Championships, our undergraduate edition. We have students competing, 16 different teams of students competing from across Manitoba, and they're competing for a chance to win over $20,000 in cash prizes. So on Startup Tree, there is an event where you can register to RSVP and you can actually watch on Zoom the final round business plan presentations, elevator pitch competition, and an exciting welcome and introduction video. So again, all of the agenda and details are in the event on Startup Tree. So I highly encourage you to check that out if you're interested in watching and attending. On that note, time's flying by. We started a new webinar series this past winter, and we have 3 left, the bottom 3 on the screen there, on April 12th, 21st, and May 5th. So feel free as well, while you're on the Startup Tree platform, to check out those upcoming webinars. Highly encourage you to attend them if you can. There are 3 incredible webinars that we have coming up, so please check them out. Details can be found on Startup Tree as well, and hopefully look forward to seeing you at those events. I do want to draw your attention to our next one on April 12th. Now, it is outside of our traditional Wednesdays at 11:30, so I do want to draw that to your attention. Monday, April 12th at 12 o'clock. Very, very exciting and special guest, David Asper, who is going to be presenting a family business case study, the family business, what can go wrong with family. Highly encourage you to, again, check out all the details on Startup Tree and join us. It's going to be a fantastic event, and we're super excited for our community to hear what Dean David Asper has to say. On that note, before we get started and before I introduce to you our 3 amazing speakers today, I do want to give a special thanks to both Lisa and Nick from the Faculty of Law and the L. Carey Vicker Business Law Clinic. Lisa and Nick are some of our most favorite fun Zoom friends, and they've been super instrumental and talented in helping organize both today's webinar and the one on Mondays. So Lisa and Nick, thank you so much. It's been a fantastic collaboration, and we really appreciate all the work that you've done to help organize today and Monday's event. Now, with that being said, today is all about legal fundamentals for startups. So I am super excited to welcome and to introduce to you 3 presenting students that are going to present on a couple of legal fundamental items. And these 3 students are from the Robson Faculty of Law, and they're contributors from the L. Carey Vicker Business Law Clinic. Today, we have Evan Podama, Jennifer Bish, and David Slonowski. So Evan, Jennifer, David, how are you 3? Welcome. Thank you so much for being here with us.
Doing great today. Thank you, Josh.
Thanks for having us.
Awesome. Well, we're super excited to have you 3. I'm going to stop sharing my screen here, and I will leave it up to you. You can take it away. The floor is all yours, and we'll connect back after your presentation for some Q&A with the audience.
Alrighty, I think the floor is mine at this point. So hi everyone, my name is Evan Podama. I'm a student at Robson Hall, as well as a student with the L. Carey Vicker Business Law Clinic. So today I'm going to go over some basics as to different business structures, as well as the what and the why of corporations. Later on, my learned friends will be going over the how of corporations, as well as discussing liability and intellectual property in a little bit more detail. Of note, for the disclaimer that you saw briefly there, just want to highlight, this isn't legal advice. And if you guys are seeking out any help, please feel free to contact us and we can go from there. Now, just very briefly, we are a free legal assistance to entrepreneurs, small businesses, startups, innovators, nonprofits, pretty much anything under the sun. And it's for individuals who don't have a lawyer and cannot otherwise afford legal assistance, where we specialize in business law. Moving forward, please. So looking at business here in Canada, the vast majority of business is small business, approximately 98%, 1.2 million businesses in Canada, of which over 40,000 are located here in Manitoba. They all have 2 main things in common: the business name and business number. This is done with registration and paying applicable fees down at the Manitoba Companies Office. It's a pretty straightforward process. Jen will be walking you through that in a little bit here. Now, as for the most basic form of business organization that you can have, we have the sole proprietorship. Realistically, you need a little bit of sweat equity, a couple $100 and a dream. It costs the least amount of money in order to register, and it's by far and away the simplest kind of organization. Now, on there, you see unlimited personal liability. Lawyers love talking about liability, and you'll see why very shortly. Now, I'm going to break this down for you here. So personal in that three-word little tidbit there means you, yourself, and you. Means you are the one responsible. Liability is the obligation to pay if something goes wrong. So for example, let's say that I have a plumber business. So I'm a plumber and I didn't put in a pipe properly. It bursts, there's water damage everywhere. Now, as a sole proprietor plumber, I am personally responsible for paying to fix the damage that the water causes. This is out of my own pocket. Now, the unlimited part is important here. This means that it's not capped as to the amount that I can owe. So it doesn't matter if the damage that is caused is worth $1,000 or if it's worth $1 million. I'm still on the hook. And if I got to sell my car or my house to make it work to pay him back, so be it. So moving onwards to partnership. Partnerships are pretty straightforward as well. The definition of a partnership is a relationship between two people carrying on a business in common with a view to make a profit. It's still really simple and straightforward, but you're also going to want to consider something like a partnership agreement. A partnership agreement sets out the guidelines and minimum expectations of how the parties in the partnership will operate. Now, they can be extraordinarily flexible. You can write them pretty much however you want. We can assist you with that. So reach out if you need to. An example of which is, let's say that you have two parties. There's one individual that works more than the other, and you want how the profits are distributed to reflect that. You can put that into a partnership. Now, partnerships can be oral as a verbal agreement between two parties, or they can also be written. They're still both binding. Now, you're also probably wondering, well, what if you don't have a partnership? If you don't have a partnership agreement, then there is default legislation that will kind of tell you how it's going to be. Newsflash, you're probably not going to like how it applies to your situation, so we highly recommend making one on your own terms. Come see us for that. Now, there's referring back to liability here. Liability is joint and several in a partnership. Now you're probably thinking, what does that mean? It means that you're all in it together. Using the same example of being a plumber, let's say that there is the Padema Brothers plumbing business. It's me and my brother, Charlie. Let's say that Charlie, not me, goes out and does a job where same thing happens, pipe is installed incorrectly, it bursts, there's a massive amount of water damage, and the homeowner that has it happen to sues Charlie. If that occurs, I am still on the hook as a member of the partnership for paying some or potentially all of the money that cost to fix that damage. So you still have to be very careful, and it's still a form of unlimited liability, potentially even more because you have more people that could trigger an event which costs you. Now, moving on to corporations. A corporation is a work of legal fiction. Oh, a quick little question there from Angela. What about LLPs? LLPs are, and that's certainly a very good point there, LLPs can limit the amount of liability that's shuffled between the parties. However, there are very certain circumstances that are involved to create an LLP. You don't just magically get to create one in the same sense as other business organizations. That would be something that we'd highly recommend you come down and you speak with us about if it's an option that's right for you. Angela, does that kind of answer your question there? Perfect. All righty. Now, moving onwards here, corporations are work of legal fictions. And what I mean by that is, because it's on the books as a law, we can make it possible. Corporations are created via legislation, such as the Corporations Act of Manitoba provincially, or federally under the Canada Business Corporations Act. Now, they are more complex to set up. They do involve more paperwork. But there's also different rights and privileges attached to corporations, as well as liabilities, that you don't have with sole proprietorships and partnerships. For example, they're taxed differently. They are still very flexible. You can still have different situations where they produce the same goods that you want to produce. They provide the same services. It's just a little bit different. Now, you've probably heard before about public versus private corporations. Both of them still have shares. Now, to describe a public corporation, that's a corporation that's traded on a stock exchange like the Toronto Stock Exchange or the New York Stock Exchange. Quite frankly, that involves a crazy amount of paperwork, and it's usually for a little bit larger organizations. You're probably a ways off from getting to that point yet. In contrast, a private corporation have shares that are closely held between private parties. So they're not listed. It's pretty much everything that's not listed on a public stock exchange. But again, they all have shares, fundamental part of corporation. Now, why would you want a corporation and what are the benefits? The biggest benefit, next slide, please, is it comes as a result of legal personhood. Now, what I mean by that is a corporation in the eyes of the law has the capacity and the rights, powers, and privileges of a natural person. This is codified in law. That's section 15 of the Canada Business Corporations Act. What that means is that there's a limit of liability for shareholders that's afforded by another section in the Act, section 45. It means that there's a corporate veil between owners of the corporation, the shareholders, and the corporation itself. Your liability is capped except in very rare circumstances, meaning you're not personally on the hook to pay the debts. So using the same example of a plumbing business, let's say it's Pedema Plumbing LLC, and the same situation happens, a pipe bursts causing $1 million worth of damage. I can't be sued personally for the amount of money that it totally costs. The most that I can lose is my initial investment into the business. Now, you're probably still wondering, that's great, that sounds almost magical, but why do we also have insurance? Well, quite frankly, your corporation's not really going to be much good for you if you're completely bankrupt as a result of being sued. So we have insurance that's in place in order to help essentially pay it out if that bad thing happens. So insurance still plays a very real role in the goings-on of a corporation, even if there is limited liability. Now, and we've got a question here. So proprietorship. That is a very good question there, Mr. Singh. And with that in mind, oftentimes it's a matter of what's right for that particular person. Sometimes it's they want to get to market very quickly, they don't have a lot of money, and the easiest way to do it is to go and form a sole proprietorship over a corporation. It can also be a little bit more daunting in order to go out and file all the necessary paperwork, which my friend Jen will get to in a little bit here. So there are pros and cons for each particular option. It really depends on what personal situation that you're in. That's why I would highly recommend reaching out to us at the business clinic, and we can go from there. And you certainly can change a sole proprietorship into a corporation in the future. You incorporate and go from there. Again, that'd be a conversation that we could have down at Business Clinic. Now, for the structure of a corporation, I want to give you guys a little bit of groundwork here. So you have three main groups of people. You have shareholders, directors, and management. Shareholders are the ones that own the company. If there are any profits, they'll collect them in the form of a dividend or a profit payment, essentially. They also get to vote on who gets appointed to the board of directors. Now, the board of directors or directors in themselves supervise and oversee the corporation. They're elected by the shareholders and they act on behalf of and in the best interest of the corporation. They're usually not concerned with the day-to-day business of the corporation, and their duty is to establish kind of long range of corporate objectives and policies and broad strategies. So more, where do we want to see this business go in 3 to 5 years from now versus how do we balance the budget today? Now, directors will also be able to appoint management. So for example, a CEO. They actually run the company on a daily business. They're the ones setting prices, negotiating with suppliers, or delegating and hiring individuals as necessary. Now, what I mean in that next little bit there, you can wear multiple hats. You can be 1, 2, or even 3 of the above groups. You can be a shareholder as well as a director, or you can be a shareholder, elect yourself as a director, and then further appoint yourself as management of the company. That's why you'll often see something along the lines of chair of the board and CEO of a organization. Now, you may come across the words fiduciary duty. Fiduciary duty in its most basic sense means that you are obligated by law in order to act in the best interests of somebody. Directors and management are obligated by law to operate and to make decisions in the best interests of the corporation. This can be taking into account a wide array of decisions. Now, in terms of the important documents here, you got 3 main ones. The articles of the incorporation are the founding document of the incorporation. They're essentially the skeleton or the bare bones of the corporation. It's usually inward facing, meaning that it controls things like the business's name, how many directors it can have, what's the total amount of shares that can be issued, things like that. A shareholders agreement, this will oftentimes become part of the constitutional documents, and it's essentially a consensus that's made among shareholders about how they want the corporation to operate in a certain way. These are easier to vote on and change than the articles of incorporation, but can still be kind of difficult. And finally, we have bylaws. Bylaws of the corporation are subsidiary rules that regulate the business or daily affairs of the corporation. This can be easily changed by the directors at a regular meeting. And that could be something like, what do we want the budget to be for this year? Now, next slide, please. This is just a very quick visual comparison for you guys of some of the main factors that I've spoken about here. I'm now going to hand things off to my colleague, Jen, who will be speaking about the how to incorporate a business.
Great, thanks, Evan. So I'm going to talk to you about just the process that you need to go through if you decide that you want to incorporate. It's a pretty easy, simple process. You can do it online. But before you do it, be sure you have your business name registered before you proceed with filing your articles. So you simply put, you incorporate by filing articles of incorporation. Provincially in Manitoba, that's done under the Corporations Act. The fee for filing is $350 plus tax in Manitoba, and that doesn't include the $45 fee for registering that business name, which I said you need to have before you file your articles. You can also file federally under the Canada Business Corporations Act if you plan to operate across the country. As startups, most of you are probably going to be operating just in Manitoba. So for the purposes of this presentation, I'll be referring just to the provincial incorporation. So if we go to the next slide, there should be a couple of visuals here. So on the left is what you'll see when you go to the site and look for the articles of incorporation. That's what the page is going to look like. And on the right, that's the website where you're going to go to. That's the company's office. And you'll see under New Manitoba Corporations, there are 2 items there. The $45 item there is for filing that business name, and the one below it is for filing your articles. There's a question about cost of incorporating federally. It's similar, it's a little more expensive, and there's more paperwork involved. I don't have the number on hand right now. We can go to the next slide, I think. So the required information that you're going to fill out on that form includes things like your name of the corporation, the address of the registered office, how many directors you're going to have, who the first directors are, the classes of shares, and also any rights and privileges, conditions attached to those shares. as well as restrictions on transferring those shares and restrictions that your business, what kind of business your corporation might carry on. There's a section for other provisions, which has where you can file any optional things that are necessary for your particular business. And then finally, naming the incorporators. And those are the people that are actually filing the articles of incorporation. So on the next slide, we'll go through the name of corporation. Every corporate name that isn't just a numbered name needs to be searched and reserved, of course. Like we've said several times, this is an important step. File that request for a name reservation. And the file, you must file that through the company's office. So when you're filing your articles, it has to match that same name that you put on your business name reservation. So make sure that that's a key thing to keep in mind. Those two names have to be identical. Your corporate name has to end with a legal element, and that can be incorporated, limited, an abbreviation of that, or also the French equivalent. And if you're incorporating a numbered name, the format is going to be number and then Manitoba and then the legal element. And there's an example at the bottom there for you so you can see. So on the next page, we're going to talk about the address of the registered office. That's the place where you're going to be keeping your books and records of the corporation. Those things include the articles, the bylaws, the minutes of meetings, resolutions, that sort of thing. You need to supply a full civic address, not just a post office box, and the address has to be in Manitoba. So on the next page, we're going to talk about the number of directors. So here you can provide a fixed number. You have to have at least one director. And if you provide just a fixed number, you have to also include the names and addresses of each of those directors that are fixed. Another option is having an unfixed range of directors. So you would say a minimum and a maximum number of directors. Those are you can potentially fill all those. You don't have to fill all of those if you're making a range. But again, you have to supply the names and addresses of at least one of those people. So on the next slide, we'll talk about the first directors and the incorporators. So the directors are the people that are responsible for supervising the activities of the corporation, and they make all the decisions about those activities. There's a low bar you have to meet. There's a few requirements. To be a director, you have to be at least 18 years old. You can't be currently in bankrupt status. That doesn't mean that you can't formerly have been bankrupt. As long as you have received your full discharge, you can still be a director. And importantly, you have to be an individual, so you can't be a corporation. You have to be an actual individual. You have to provide the full legal names and home addresses of all the directors. And at least 25% of those directors have to be residents in Canada. So just as with the directors, you have to provide the full name and home address of all the incorporators and their signatures. And those are the people who are going to be filing the articles. If you are a director not listed as an incorporator, you'll need to sign something called a consent to act as first director form, and that you file along with your articles of incorporation. And as with directors, incorporators have to be 18 and they can't be in bankrupt status. The big difference is, though, with an incorporator, you may be a corporation and be an incorporator of another corporation. So on the next slide, classes of shares and restrictions. All share capital corporations are authorized to issue shares. Shares are the pieces of the company that represent ownership. That's like Evan had said, that's whether it's privately held or publicly traded on the stock market. You issue your shares when they are purchased, and then the owner of that share becomes a shareholder in the corporation. In the articles, you will indicate how many shares you can issue, and if you want to divide them into different classes with different restrictions attached to each of those things. So there's no limit on the number of classes of shares that you can authorize. You can be a maximum number, or it can be an unlimited number. That doesn't mean that the shares have been issued. It's just a potential number that you can issue. Unrestricted shares. So if you put no restrictions on the shares, That will give the holder the right to vote, the right to receive dividends, the right to receive remaining property upon dissolution of the company. You can also restrict shares by separating them into different classes with different rights. So for example, you might say Class A is unrestricted and Class B comes with just a right to vote, for example. You might require some professional advice from an accountant on your shares because there might be some tax consequences based on the way the shares are allocated. So do talk to an accountant before you make a decision here. You can also keep this section really simple at first and just use default choices. You can always amend your articles in the future if you need to. So on the next slide, we will talk about restrictions on those share transfers. So when the shares are issued, the shareholders may resell those shares unless they're restricted. If you want, you can put some restrictions, and that would afford some control by the directors and the shareholders as to what happens with those. Will you be getting these slides? I believe we can share the slides. And we'll be sending out a handout too for just some ideas that you need to turn your mind to when you're incorporating. So some restrictions that you might want to do, this is pretty common, is that you can prohibit the transfer of shares without board approval. That's one restriction you might do. Or you can say that shares can't be transferred without getting a certain percentage of approval from the shareholders. That's another option for you. And as a privately held corporation, you might want to provide at least one restriction just to retain some level of control over your company. So on the next slide, we'll talk about restrictions on business. So most companies don't restrict their business activities. There might be some reason to include some restrictions. For example, if you're an incorporated health professional, like a doctor, you have to restrict your business to the practice of just that profession. And you can include other other items in your articles of incorporation, such as legislation that pertains to your particular business. I have a question here. If your share prices are currently 1 cent, how do you change their price? How is that determined? Pricing the shares, that's a more complicated question. I'm not prepared to answer that right now, but perhaps we can leave that to the end and get some of our supervisors in to talk about that. All right, I'm going to defer that one for right now. So the next slide, I think you have to go back one more. Yes, organizing. So after you've incorporated, you've successfully handed in your articles of incorporation. So now the Corporations Act requires you to organize. And that means that you have to hold an organization meeting to do things like make your bylaws, adopt your forms of security certificates, authorize the issue of securities, appoint your officers, appoint your auditor, and make your banking arrangements and any other business that you need to transact. So on the next slide, so you've filed your articles and you've organized, so congratulations, but you're not done yet. You have to maintain your corporation every year. There's some things that you have to keep your mind on every year. And for that, I'm going to put into the chat a document just to, it's an overview of things you need to keep your mind to when you're maintaining and also when you're incorporating. So you have to do things like have an AGM every year. You have to file your annual return online at the same place where you filed your articles of incorporation. And these sorts of requirements apply to all corporations, even if you only have one director. And that's it for my section. Is there a question here? If you're issuing to third parties, it's partly a market value proposition, i.e. how much will a buyer pay? In other cases, the share value is derivative of. Thank you, Dean. Dean Asper has kindly brought an answer to the chat room. I'm going to put in the chat, like I said, that document, and that's just an overview of things that you might want to keep turn your mind to when you are incorporating. And now I'll pass this over to my colleague David to talk about liability.
Okay, so jumping over into my section here now, I'm going to give us a quick run through of just a few other topics that will commonly come up for new businesses. We're going to start with liability, move into contracts/agreements, and then finish up with intellectual property. So starting with liability, everybody can't afford to be sued. It's potentially business ruining cost. So starting with limiting liability, everyone knows every transaction you do carries some amount of risk. These risks can be small, large, very obvious, or maybe a little more hidden. There's all sorts of different types that will come up in business, just as many types as there are things you can do. The key about it is that risk and liability can be reduced. You can do certain things to make sure that the impact of those risks are as minimal or as manageable as your business can handle. But you have to remember there's no way on earth to possibly eliminate all risk. It's always going to be present, and there's always still going to be some liability somewhere for something. Nothing in life is free. So things that commonly are done to mitigate risk and limit liability is inclusion in clauses in contracts that will set out the amount of liability that's taken on or exclude other types of liability that could arise through the contract. There's all sorts of limitations on these about how much you can actually limit a contract out of and limit. Different jurisdictions allow different things, different types of contracts allow different things. Getting into specifics would be far too much for this brief presentation. Certainly if you have other specific questions, come contact the clinic. We'll do everything we can to talk you through that and work out some sort of possible solution to your liability there. Other great practices to limit liability and risk is following regulations. It seems kind of obvious, but you'd be surprised how many businesses end up in quite a lot of trouble by not following the regulations and essentially the laws of running a business. If you end up in non-compliance with regulations, can be hefty fines, or your business can be completely dissolved by the regulator, which obviously is quite a big issue. Besides that, just good business practices is a great way to limit risk. This just means being ethical. Keeping good records is a very good thing, and other stuff along those lines. And then lastly, when all else fails, there always is insurance that for that liability that still might sneak through. Being able to not bear the heaviest brunt of that possible damage is a good solution. Now, that being said about insurance, how much insurance you can get is going to be up to whoever is providing your insurance. There's often other liabilities that go along with trying to get insurance. So that's always something to weigh and consider. Moving on to agreements and contracts. They're fundamental to business operations. Anytime you're dealing with another entity of any sort, it's probably going to be through an agreement or a contract of some sort. Within legal definition, contracts and agreements are exactly the same thing. There's no special difference on what is an agreement or a contract. They both carry the exact same sort of weight. They essentially will bind a person or a company to certain legally enforceable actions or conditions. And key thing to remember at this point is that not everything that constitutes a contract will be in writing. You can have a contract that is just something you said to someone, and then they all of a sudden have expectations and you've created an obligation to them. So very important to be cautious in your dealings and be sure that you're being very clear on what you're doing and actually setting out your obligations as a contractor or not. Some things some companies do to manage that is sort of preface or include on all their communications that this does not constitute a contract unless it is duly signed by authorized persons, etc. There's all sorts of little things like that that just make sure that you don't accidentally end up in a contract you didn't mean to be in. That being said, there are certain contracts that always have to be in writing. These would be things like employment contracts, greater than 1 year terms, as well as any real estate transactions must be in writing. There's other ones as well, but just for example, there are some things that you can't be bound to just because it's not in writing. Common business contracts that everyone's probably heard of, non-disclosure and confidentiality agreements, used typically to protect your trade information, sales figure, anything that you might be disclosing to another party that is of some value to you in your business will commonly be covered under something like that. Other ones, contracts of sales, very straightforward. I buy something, that's an agreement in a contract that I get the item, you get consideration, money, I agree to do another service for you, whatever it might be. Licensing contracts cover situations where you want the use of a particular item, but without possibly taking the underlying ownership with it. Terms of use contracts, these are typically, you'll probably most often run into them for websites, applications, and other things like that. They are basically an agreement between the user and the person who created or provided the platform for how the user agrees to use the platform. They are typically what we call contracts of adhesion, which means they're not negotiated, they're take it or leave it. There's all sorts of considerations that go into those. And then obviously employment contracts, and then basically anything else you can possibly think that you might come to an agreement with another person about, where there's an exchange of value of any sort, can be a contract. So it's really limitless. It's a fun area of law for sure. Moving on to intellectual property. This is a very important field for businesses that are just starting up. There's, at their most basic, there's 4 types. All of them will be more or less important to any particular business, depending on what the business may be. We have copyright, trademarks, patents, and industrial designs. We'll go into each of those on individually. So starting with copyright, copyright applies to original creative expressions. They do not need to be registered. Anyone who creates something in Canada that's original has the copyright to it. If I write a poem right now, I don't have to go register the poem anywhere for me to have protection over that potentially. A copyright will last for the lifetime of its creator, plus 50 years from the calendar year of their death. And things that are commonly covered under copyright would be music, pictures, books, speeches, recordings would be covered under copyright as well. Besides that, there's not much extra you need to know besides don't use someone's copyright if you don't have it. And moving on, we'll go to trademarks. Trademarks are symbols or other things the like that can be used to identify a particular entity's goods or services. The registration is common with them, but is not necessary. In Canada, there is a common law recognition for trademarks. It requires you to have been using the mark for a particular amount of time prior to being recognized. So registration is probably still advised, especially if you're just starting out and you want to be able to protect your marks right away. Registration is on a 10-year basis renewable. The same thing's true in the United States as here in Canada. It's on 10 years and you got to renew it every 10 years, or it lapses and it ends up in public domain, or someone else might try to register it, who knows. I got a question, what's the difference between registering your business name and trademarks? That's a very good question. Your business name is the official name of your business. Think of it like it's the name on your birth certificate. It's the exact name that refers to your company on any official records. Whereas a trademark or a trade name is the name that people know you by, or that you might do business under. So think of that more as a nickname or something. Does that answer the question? Advantages of registration, good question. We'll be getting to that right when we cover the different types. So moving on from, I guess, the types of trademarks that we commonly see: logos, mascots, word marks. And yes, both names can be different. It's not strange at all for someone to have a different trade name than a business name. Like we said, your business name can be a number. You can be a number company where you're 1, 2, 3, 4, 5, 6, 7 Manitoba Limited. Obviously, you're not going to put out a storefront sign that says 1, 2, 3, 4, 5, 6, 7 Manitoba Limited. You might be David's Bikes or something. So moving on, we have patents. Patents are unique solutions or methods of doing something. They have to be registered. Registration's all that matters on a patent. It's the first person to register that patent is the first person to own it. It doesn't matter if they came up with the idea, or if they made it first, or if anything. If you don't register the patent, you don't own the patent. The key thing about a patent, though, is it has to be new, it has to be useful, and it has to be inventive. New is pretty straightforward. Useful is a little funny. It doesn't mean quite as useful as you think it does. It just means that whatever it's doing has to do something. And then inventive is really, I think, where a lot of patents might succeed or fail. And that's where inventive means non-obvious. It has to be something that not everyone would just come up to do as a solution or a way of doing something. That's where really the creativity and the uniqueness of a patent shines. So that's the basics of patents. And then lastly, we have industrial designs, which covers the features, configurations, patterns, ornamentations applied to a finished good. So for taking an example of something like an iPhone, the shape of the iPhone and the idea of having a screen on the front of a phone with a microphone of that is not a patent. That's an industrial design. The patent there's a lot of confusion between the two because they're both very industrial and mechanically orientated. But patents are applying to a method or a solution or a way of doing something, whereas the industrial design is really the actual physical good. We have a question on provisional patents. I'll address that, I guess, in the question section later. So common things that you'd see in industrial design would be very distinctive looking products, even potentially coloration of particular products, as well as the very, very commonly used packaging is covered under industrial designs. So now going on to sort of the common points between all of them and registration of any of intellectual property. All types of registration does carry costs. It does cost some money to register any type of intellectual property. And usually you will do a registration through an agent in that appropriate type of intellectual property. What does registration get you? Well, it's an evidence of the existence of your intellectual property, and it proves ownership of it. That being said, the Canadian Intellectual Property Office will not defend your patents for you. All they will do is keep a list and register it. If you have a trademark on something and you want to stop someone else from using it, the office won't do that for you. You have to take them to court or send a cease and desist or whatever your solution might be. But if you have the evidence when you get to court, the court will just say, oh, well, who's it registered to? Done. And the key thing, biggest, most important point about anything about intellectual property is do not use someone else's intellectual property without their consent. The costs of doing so can be extreme. Just as an example, if you use someone else's copyright and you make profit on that copyright, someone can come after you for all the profits you made in association with their copyright, in addition to damages and else. It can be quite the heavy cost if you do that. Some of the ways to make sure you don't use someone's intellectual property without consent is doing things like registration searches, where you will look up trademarks or copyrights to see if something you plan to do might be infringing on someone else's copyright. The other thing, if you have to really use someone else's intellectual property, is setting out licensing agreements that you will go to the owner of the intellectual property and ask for a license to use it. So I think this will wrap up the body part of our presentation, and we'll move on to questions. Josh, did you want to chime in to manage the questions section, or should we do that? Or
Absolutely, I can facilitate that. I just want to start by saying thank you so much, Evan, Jennifer, and David. That was an excellent presentation. Really appreciate that. So yeah, we will move into some Q&A here in the last few minutes. So again, invite anyone in the audience here. If you have a question, throw it in the chat. In the meantime, I do believe, Quinn, you had 2 questions in here, but I want to cycle back to your first one earlier about how to actually issue shares. So if anyone could shed light into how to actually the process of issuing shares, and Quinn had asked if the articles of incorporation need to change when you actually issue the shares.
So that question was about pricing, correct?
No, he asked one just before the pricing about how to actually issue the shares, and if when you issue the shares, do the articles of incorporation need to change?
Oh, okay. After you've actually issued them. Okay. I'm going to ask one of my supervisors to answer that if they can, because you have to issue certificates to show that you've issued shares, but I haven't done that process myself. So I was wondering if Lisa or Nick might be able to answer that question.
Sure. It's hi. Let me see here. Let me put my camera on. You know, it's a great question. You know, it's a good question. Who issues shares? Well, in a corporation, the directors of the corporation have to, at a meeting, decide to issue shares, and that can only occur by a majority vote. So, so the directors, it's the director's decision, and they have to pass a resolution to issue shares, the number and generally the value of the shares, and that has to be recorded in the minute book. Those shares, of course, then are, you actually have to, if it's a private held company, then often, if it's a small held group, there will be likely a shareholders agreement or a unanimous shareholders agreement where the shares may only be issued in some cases to existing shareholders, right? If the directors decide that they want to issue it beyond the existing shareholders, you know, that can have an effect on the control of the company, because what you're doing is reducing the amount of shares that tightly held group might have. So That's why the directors will have to determine that. Also, in a small, very small company, it's often the shareholders themselves that will determine what the value of the shares are, usually through some form of valuation that is captured in the shareholders agreement. So that's how you issue shares. Oftentimes there are, like Jennifer had mentioned in her brief, there are restrictions and controls on the transfer of shares. If it's a small privately held company, they may not want it being widely distributed. They want to maybe control the control of the company within a smaller group. So it all depends on the circumstances as to, you know, how do you issue shares, right? It will depend on clearly the directors. It'll depend on who the shareholders are. And it'll depend on every other circumstance. Now, if you want to issue shares to the public, it becomes really complicated, like Jen had mentioned in her presentation. You don't necessarily have to go to a stock exchange to do that, but if you're going to be issuing shares to ordinary members of the public, then you need to really, you have to engage a lot of professionals. You need accountants, financiers, you need you know, lawyers who specialize in that. You have to engage the Securities Commission, whose role is to protect the public. You'll probably need a prospectus that describes what the company does, how it's financed, how it operates, who manages it, including all the risks that the company may face. And it's not a simple process. So if you think it takes somebody asked a question earlier about the Canadian Business Corporation Act and how much does it cost to incorporate. It depends on whether you incorporate on you're filing online, or whether you request an express incorporation, or if you do it by mail. You can do it online. You can incorporate a company online for I think it's $200 or $250. That will give you your articles of incorporation. You'll have a name, but there are a lot of other steps that you have to go through before you go out looking for money, whether it's by way of loans or by way of shares, and all of that becomes much more complicated. Okay, so I recognize that's perhaps not a very good or thorough answer, but it's not as trivial an exercise as simply incorporating, saying we're going to create shares and sell them. There's a lot of steps you have to go through. You have to engage an accountant, should engage an accountant. Dean Asper had mentioned in the chat, how do shares values be determined? There's different ways of doing that too. And you really, in many cases, it is related to really what the value of your company is. So if you incorporate today, get it online, you get it back, the value of your company is probably zero. So you can't say, well, I'm going to have an unlimited amount of shares and I'm going to issue shares for $100 a piece. Like that isn't going to work, right? So you're going to have to go through far more steps. Your company has to have some value for you to be able to sell shares, right? Unless you are a small company and you've got a whole bunch of people that are just speculating and hoping for the best, and that the value of the company is going to grow over time. But that's why there's a Securities Commission who, well, you know, you have to put together a very detailed prospectus, identify all the risks associated with that, because what wasn't mentioned during the presentation is that if you become a shareholder, your investment in the company is 100% at risk. So if you invest $1,000 in a share, or if you invest a whole bunch of money in these shares and the company goes broke, you've lost every cent, right? Like it's gone, everything's gone. So people who have money that invest in equity, and they're going to do a lot of due diligence to make sure that their investment is not going to be lost. I hope I answered that question. Don't want to sort of skirt around the issue, but I don't want to create any expectations that just because you create a corporation that it's an easy way for raising capital, because it's not necessarily the case. Yeah. Did I answer the question, Josh?
Yes, thank you, Nick. And I think David's just piped into Dean Asper into the chat here, and he can give a simple answer as well, he mentioned.
Yeah, I mean, the question I think was, Quinn, do you have to amend your articles to issue shares or as part of issuing shares? And the answer is partly that's why when you go to incorporate, the lawyer or whoever's doing the incorporation will probably be advising the broadest possible share structure, so that you may have 15 classes of shares, and your founder shares might be your Class A shares, and your seed round or your second round of financing might be Class B shares. And the articles of incorporation will typically provide for that right at the outset. If you want to start changing the share attributes and the characteristics of shares, you might need amendment of the articles, but that's why when you go to incorporate, the advice will be quite often to keep it as broad as possible. And it might seem like it's over the top, like, hey, wait a minute, I'm just starting a small little business here. Why do I need all this? And the answer is to keep things as flexible as possible as the business evolves.
Perfect. Thank you so much, Dean Asper. Appreciate that. And thank you, Nick, as well for your thorough response. Just in the interest of time, I do know we've hit our hour. So if anyone has to sign off, thank you so much for joining us. But if our presenters are okay for a couple more minutes, there's a couple other questions in the chat we can quickly get to. First of all, quickly, does a provisional patent allow you to change the design of your device within that 1-year grace period?
I guess I can take a crack at that. Not 100% sure on what a provisional patent is. If that is that the idea of, are you talking patent pending, or are you? I'm pretty sure as far as Canada patents go, you have patents or you have nothing. So if there's no sort of temporary patent or whatever. Moving on.
Perfect. Thank you, David. At what point would you recommend a startup to engage lawyers, and what type of due diligence is required before one engages a law firm? Is it ever too early to reach out to a lawyer?
I would hazard a comment here and say no. The ability for the lawyer to help assist at every stage of the process is going to be very important, especially when we start doing things like understanding where potential liabilities will come into effect. That may not even be known at an earlier stage for a entrepreneur. So it can be very helpful to reach out to a lawyer at an earlier stage. That we can point that out and try to minimize that risk moving forward.
Perfect. Thank you, Evan. Another question in here from Jake: similarities and differences between provincial and federal incorporation. Is it just where you can operate your business, or is there anything else from a legal perspective that they need to be aware of for the differences?
Well, I'll let other people add to that, but the process is similar, but my understanding is that it's a little more complicated and a little more expensive to incorporate federally. And just to keep things simple, if you are operating, having provincial objects as what you do, if you have something in Manitoba that pertains only to Manitoba and there's no possibility of it operating elsewhere in the country, then just doing provincial incorporation would be the best move. But if you plan to operate across the country, you might want to consider federal incorporation.
Perfect.
I don't know if anyone else has more to add to that.
Perfect. I appreciate it, Jennifer. Last question here before we wrap up. I know before you or when you go to register your business name, sometimes it may get rejected if it's too similar of a name to another existing business. Any tips or advice on where entrepreneurs can look before they go to register the business name, where they can do some research to see if there's another business out there that might have a similar name, or any tips and advice on that?
So it's my understanding that when you do the business name reservation, what you're doing is it incorporates a search. You should also look as well, like you do your own searching and see if your business name is repeated elsewhere. But what that reservation does is it reserves the name. It doesn't register the name right away. So you have some time after that reservation is made and they've looked up and just to see if there's any conflicting names out there. After that, then you decide if you actually want to register that name. But it's always good to do your own homework as well and do your own searching. Make sure that you're not infringing on somebody else's name.
Awesome. Thank you so much. Well, with that in mind, and there, Nick just put in the chat too, search name on Google. Google is a great tool. With that in mind, I want to thank everyone so much. Evan, Jennifer, David, thank you so much for your presentation. And thank you everyone for joining us today for this webinar. If you have any other additional questions, feel free to reach out to the Business Law Clinic. They're here to help and support you and answer your questions. So don't hesitate to reach out. Again, don't hesitate to reach out to us at the Stu Clark Center too if you have any other questions. Thank you so much for joining us and for spending the time. Enjoy the afternoon, and hopefully we'll see you on Monday with Dean Asper's webinar as well. So until then, enjoy the rest of the week and the weekend and the warm weather, and take care.